Okay, how's that? People can hear me just fine? Good. Well, thank you all for coming. It's such a treat to be back at HASP in the flesh. I've did a few kind of Zoom presentations the last couple of years and totally understand the need to accommodate folks' needs and health and all those sorts of things in a pandemic, but doggone it, it's good to be here in person. And so I really appreciate that. Thank you all for coming, and for those online who are tuned in. Yeah, so I am guilty, I would say, of overhyping the work of the Supreme Court. It's an occupational hazard. It's a problem for someone who's a court junkie. Every time I do a HASP presentation or a speaking gig, at the end of a term, invariably I'll say, wow, that was one for the ages. So here today, I'm going to say again, that was one for the ages, only this time I really mean it. This one was one for the ages. I had a prior life as a lawyer and then have been in the academy for almost 30 years, studying law and the courts. This is, I think, by some margin, the most significant term that I've seen coming out of the court. Okay. Roe versus Wade in and of itself, Roe is probably enough to warrant that appellation of historic term, right? A case, the overturning of a case that, right, a half or more of the country view as a precious right that is a key to women's autonomy. And at the same time, another large swath of the country view it as among the worst decisions ever to come out of the court, right? When a case like that, with that significance, is overturned, that's a big deal. But it was a really big term for other reasons as well. I mean, this was a term, as I will dwell on in a little greater detail, when conservatism really took root in the court. And there was a serious change in direction in a way that we have not seen in decades and decades, and a change that may well be with us for some time. It was a case that was significant for the elevating of a particular way of deciding cases, which we'll talk about more. Originalism. That has sort of become the default mode of interpretation. That's new, and that's a big deal. And then just other cases, whether it was religion, guns, the administrative state, immigration, a lot going on the court. And we have about now like an hour and 22 minutes to cover it. And that is inadequate. I'm doing this at another place that shall remain unnamed, and I'm doing 3 weeks, 3 sessions. That's going to be a lot easier. And for me, again, an occupational hazard of a lawyer turned academic is I have a hard time being concise, to the point, right? I love the sound of my own voice and tend to run on. So this is a challenge, all right? And we are going to do our darndest to get through a lot of material and at the same time, hopefully kind of hit on what you all are really interested in. So I'm not going to lecture for an hour and 10 minutes and leave 10 minutes at the end. That's, many of you, I see lots of familiar faces. You're kind of familiar with my modus operandi, and that's having some interactive.
Picture, they're in the classroom, I take it?
Conversation as we go. So yes, I am used to and encouraging of unruly college students to jump in and push back and interrupt. I also have 3 teenage daughters at home, so I'm accustomed to that. I would encourage you as I'm speaking and something doesn't ring right, or you have a question or a comment, or we need to clarify, yeah, get your hand up in the air. We do need to run it through the mic so the people online can hear, but just get your hand up. Bob will get you a mic. I will certainly pause at various points and catch my breath, get a drink, and that would be a good time to jump in with questions. And then I will also reserve some time at the end. You've got an outline. We won't get through it. I never do. You know that, for those of you who are familiar with me. So what I would like to do, rather than dissecting the key cases, what I've tried to do is kind of identify a few big lessons, what I've called takeaways. I think four takeaways that I want to talk a little bit about. And in the context of talking about those takeaways, I will reference the key cases and we'll give you some background on those key cases. And then, time permitting, we'll sort of pivot to some questions that are out there for us to think about as we move forward. I mean, it is now August 9. And we are less than 2 months away from a new term that already has some big cases. I won't say it's going to be a historic term, right? But it's got some big cases coming. And so we need to sort of be mindful of sort of larger questions that this term raises for the court. And it's for its standing as one of 3 branches of government, for its standing among the public, how it's going to do its business in the future. Just some really fascinating things to contemplate. So we want to leave some time for that. All right. So 4 sort of takeaways or 4 main observations that I would derive from the term that we've seen concluded at the end of June. Point number 1 is that we now have a solid conservative majority on the Supreme Court. The conservative court has finally and truly arrived. After any number of years where the chattering class has talked about how conservative the court is becoming, that really hasn't been the case. That really hasn't been the case. And in fact, even as the changes have occurred in the personnel and either liberal or sort of wobbly, mushy Anthony Kennedy type centrists have given way to solid conservatives, there have still been a couple dynamics that have sort of kept the court more sort of centered. All right. And that has to do with sort of the balance on the court, the balance between conservative and liberal blocs, and who is sort of in the middle mediating those conservative and liberal blocs. Okay. And so for some time, for more than a generation, going back to the 90s, so just kind of the crudest sort of arc of history in the court is a fairly conservative court up until the early 1930s, mid 1930s. FDR, 1937 on, is able to completely remake the court. He gets 8 appointments, okay, and he gets to remake the court. His New Deal program is pending. So what does he do? He chocks the court full of good liberal, mostly senators, right, who are going to back him up on that. And so from that point on, then we really had a solidly liberal court. Okay, that moves into the 1950s. Earl Warren becomes chief. The Warren Court from the early 50s to the late 60s is sort of the high point, right, of liberal jurisprudence. It's really sort of a revolutionary, more than evolutionary kind of phase of the court, the judiciary, the expansion of rights in all sorts of ways, right? He gives way to Warren Burger in '69, who, and there are some gradual, over this stretch of several decades, Republican presidents get to pick, I forget how many, 10 or 11 appointments to the court, but they tend to pick appointments who don't necessarily, if they started off conservative, they don't necessarily stay that way. Okay, but there is some shift over time in the makeup of the court. We get into the Burger Court, that gives way to the Rehnquist Court, and that liberal court gradually transitions into sort of the balanced court. Okay, I went to law school. I started law school, and I almost hate to admit it, in the fall of 1982, which was 1 year into the creation of the Federalist Society. And if you know anything about the Federalist Society, right, they have become responsible for Republican appointments to the court. The Federalist Society is this very active, influential kind of conservative policy and think tank, legal think tank organization. The Federalist Society was created in 1981. I was in law school at Minnesota in 1982. At the time, the Federalist Society was viewed as just a bunch of wackos who were completely on the fringes. Because even then, right, in the academy, it was largely sort of a liberal consensus. Okay, and then gradually through the 80s into the Rehnquist court, with the influence of the Federalist Society, other conservative policy shapers, right? The court gradually shifts and it becomes this sort of balanced court, right? And we get a conservative kind of block and a liberal block, and really from the 90s on through the aughts, through the 2000 teens, that balance is preserved. Even as conservatives get more appointments to the court, even as when we get through the Trump presidency, the balance turns from sort of a little left-leaning balance to a little right-leaning balance. We have people at the center. First, Sandra Day O'Connor, then she's replaced by Anthony Kennedy, who is then replaced by Chief Justice John Roberts as the deal maker, the swing vote at the center, who determines which way the court is going to go. Neither O'Connor or Kennedy I would describe as a dogmatic or hard ideological conservative. They were sort of dispositionally right-leaning, but they were eclectic. They could lean sort of in either way given the issue. And so that sort of was good at maintaining this balance. And then Chief Justice Roberts becomes chief in 2005. And then even as the court under Trump's presidency and gets these multiple selections to the court turns more conservative, Roberts slots into that middle, that position in the middle. And he becomes arguably among the most influential and powerful jurists ever to be on the court, because he is combining two things. Number one, he is the swing vote, right? And among the two blocks, he's the fulcrum at the center. And number two, he's the chief. And so that gives him power and ability to make some strategic decisions. And John Roberts, more than anyone else, very strategically and intentionally worked to maintain that balance. And he worked to kind of in the interests of the reputation and the standing of the court. He worked to sort of make sure the court didn't zag too hard to the right too quickly. And he cast some votes that left conservatives scratching their heads unless you knew what he was doing, which was to try to maintain that balance on the court. And that incredible influence and power lasted 1 year. 1 year, okay? And it lasted until Amy Coney Barrett replaced Ruth Bader Ginsburg. And a deep conservative replaced an iconic liberal, right? And that 5-4 balance changed to 6-3, right? In a conservative direction. And so there were, efforts by John Roberts in this historical term just completed to do what he had done previously to no avail. Right, the leaked Dobbs opinion showed him striving to get some conservatives to join him in being more measured, more incremental, more sort of gradual in what the court was going to do on the issue of abortion and Roe versus Wade, to no avail, okay? And so that altered balance, that altered dynamic has resulted in a term that is among the most conservative terms in a long, long time. And so you can see it, right? You can see it in the cases, right? The overturning of Roe, which had been with us since 1973. We'll talk a little bit about a trio of religion cases that came down on sort of the more traditional side, really solidifying the court's approach to religion, a gun case that makes it harder to regulate sort of gun rights. One of the cases, unless you follow law to an unhealthy degree, you may not have heard of a case on administrative law that, other than Dobbs, is probably the most significant case that comes out of this term, and that could really alter sort of the bureaucratic state and how it functions. There was one empirical study I came across that put the court as the most conservative since 1931. And if you know anything about your history, right, 1931 was this reactionary conservative majority of the court that had been overstayed their welcome. They had been on the court for decades. They resisted the New Deal. They resisted progressive policy happening at the state level. It was that conservative majority that goaded FDR into his ill-conceived court packing plan that went badly for him. So to put it briefly, this is a conservative court. Okay, and it's the most conservative court that we have had in a long time, and pending, right, how the future unfolds, pending possible changes or lack of changes in personnel in the years ahead, or depending on who goes, who retires, who passes away, and how they're replaced and who gets to replace them, right? This could be a conservative majority for some time to come. Only time will tell. Number two, and here I need to be careful because one of my research areas is religion and politics. So I need to be careful not to head too deep into the weeds on observation number two, which is that this court is the most pro-religion a court that we've had again in modern history, going back to probably the mid-1940s of the last century, at which point religion kind of emerged as a constitutional issue. Up until 1940 and then 1947, the religion clauses kind of lay dormant. Not much happened with them. Okay, and then for a variety of reasons we can get into, religion became an issue of real prominence in the court. And this court is more sort of pro-religion than at any time going back to that period of time. Lee Epstein, who's a well-known constitutional scholar, she and a co-author did a study cataloging the religion cases. And there was something like almost 100 cases going back to the beginning of the Warren Court in the early 1950s. Okay. Among the Warren Court and religion cases there, they heard 46% of those came out on sort of the pro-religion side. It was up to the 50-something in the Berger Court, Rehnquist Court, low 60s. With the Roberts Court, her study shows it to be 87% of outcomes kind of on the pro-religion side. Another quantitative study identified 15 cases that dealt with either the Free Exercise Clause or the Establishment Clause since John Roberts became chief in 2005, and that 14 of the 15 came down on the religion side. Okay, and so we have a court that is solicitous of religious liberty, and at the same time is much less concerned about breaches in the wall of separation between church and state. Okay, so let me really quickly try to give a thumbnail sketch of the three cases that the court heard this time, and then draw a few observations, and then maybe I'll pause and get a glass of water. So get your questions ready. Okay, three cases: Shurtleff versus Boston. That was an easy one, as is evidenced by the vote, which was 9-0. A unanimous decision by the court came out of the city of Boston's practice of allowing one of the three flagpoles in front of City Hall to be used by outside groups to display a flag. Okay. And in the years that they had allowed this, there had been close to 300 requests by organizations or private actors to use that flag, to use that third pole to display a flag. And the court in the city of Boston had never said no until Shurtleff came along. And he wanted this, and he represented an organization, but Shurtleff, the individual, is the named party. He was an activist of some sort. He wanted to display a Christian flag. I'm not even quite sure what that is. Some of you may, but the court said, no, that would be an unacceptable establishment of religion. That would violate the Establishment Clause. And so he sues, goes to the court. It's a fairly easy one for the court to display. Okay. The fact that they had heard almost 300 prior requests, had never said no, right? That really indicated the court, the city, I keep saying the court, the city was not controlling this speech, right? These flags, the message that was being displayed could not be ascribed to the city, right? This was private speech. And if that's the case, if it's private speech, then the city needed to treat a Christian message the same as other messages. And that's solid law, that's standard law from prior cases, that in this instance, the city saying no to Shurtleff was a clear case of what we call viewpoint discrimination, discriminating against him and his speech rights because of the content of the speech. And that's a no-no. Okay, that's a no-no. And so that's sort of well established, right? Access to public fora, that religious groups, religious actors, they are deserving of the same treatment of their secular counterparts. Okay. And again, 9-0, fairly easy case. Okay, that's Shurtleff. Case number 2 is the case of the praying football coach. Joseph Kennedy. The case is Kennedy versus Bremerton, I think Bremerton School District. It too involved kind of free speech and also free exercise of religion by a high school football coach at a public school, Joseph Kennedy. The record at the court was murky and muddy. It was really kind of mucked up the case. So there were lots of differences over what actually happened, right? And each side kind of portrayed their version of the facts to serve their interests. But Joe Kennedy was a football coach. He was an offensive or defensive coordinator, I forget which one. And he was in the habit of, after the game, going onto the field, kneeling at the 50-yard line, and having a time of prayer. Okay, at least according to the majority, at some point in time, people started joining him. Okay, he didn't ask people to, he didn't require players to. According to the majority, this was something that sort of organically happened, and students would and players would come out and join him at the 50-yard line. And at some point, right, people are lingering in the stands, and it becomes an issue. There are complaints. The school district and Kennedy, the coach, try to kind of work out some arrangement. That doesn't work. He keeps praying. The school fires him. And in a good American style, he sues, okay, claiming this is a violation of his religious speech and religious practice rights, okay? And the court sides with him, okay? The court agrees with him by a 6-3 vote. Along sort of the ideologically predictable line, 6 conservatives versus 3 liberals. And the court essentially says this is a matter of private speech. He's not going onto the 50-yard line as a coach, as a school employee. This is something he personally is doing, and he's allowed to do that. And the court sort of poo-poos or waves away possible problems, right? That this might be a kind of implicit endorsement by the school. That would be an unacceptable promotion of religion. They poo-poo the idea of coercion, which is an idea in the past that has been an issue in kind of prayer contexts. And finally they say, and even if this is offensive to some, this is a way in which we practice pluralism. And this ought to be something where people who even differ, we should be able to sort of tolerate and abide differing views. It's hard to say how much stock to put in this case in terms of its future, the future ramifications, other than to say the court has taken a very expansive view of prayer in kind of public settings, whether it's at a football game or whether it's at the meeting of city council. The court has been increasingly sort of tolerant of prayer in public settings. This seems to be in that vein. Okay. The third case, I think, is the most significant, and that's the case of Carson v. Mackin. Carson v. Mackin came out of the state of Maine, which is, I don't know how you measure this, but it's sort of viewed as the most rural of the states in the nation. And this was a surprise to me. I'm from Minnesota. I thought Iowa was the most rural, but Maine is. And because they're rural, a common problem in Maine is being able to provide education to students who are living in the very sparsely populated areas, in those areas where they cannot support their own school district. Okay, so the state has a law, a tuitioning, it's called a tuitioning law, where they provide tuition to families and students living in those very sparsely populated areas to support them going to school in an adjacent district. Okay, and the law allowed for students to use that tuitioning to go to public or private, but not parochial schools. Okay, to go to public or private, but not religiously affiliated private schools. All right, and again, the concern was that that would be an unacceptable promotion of religion under the Establishment Clause. All right, a handful of families who are living in those areas, they want to send their kids to get a religious education. They file a lawsuit. Case goes to the Supreme Court, and the court again under that kind of predictable 6-3 divide sides with the families and rules against the state and that tuitioning law. And the basic kind of reasoning is that if the state is providing what they call a public benefit, in this case, tuition to help go to school, right, to get an education. If they provide a public benefit and they open it up to private schools, they cannot discriminate against private religious schools. Okay, so the state of Maine could have said you can only use this at public schools. But once you open it to private schools, you can't discriminate against private religious schools. Okay. Up until this point, there had been some argument. It was clear that states or governments providing public benefits, that they could not discriminate against religious people or religious organizations because of their religious identity, their religious status. There still was a question before the Mackin case whether the state could discriminate against or ensure that public benefits didn't go towards religious activities, religious uses. In other words, there was this distinction between what the court called status and use. After Mackin, that distinction is gone. Okay, that's the government providing a benefit for the public cannot discriminate against religious actors based on their religious identity, or even if there is some that money goes for religious purposes. In this case, religious education. Okay, so that's a big term. Okay, and that's going to have large ramifications. So there's a hand in the back. So let me take a pause. Yes.
Can the religious school then be required to accept students of all religions?
Absolutely. Yes.
Because they couldn't discriminate if they're going to accept this money from the state.
Right. Yes, that is clear, that there cannot be discrimination against a particular faith, a particular denomination. I think no court would allow that. Yeah. I was going to offer one other point on that, and I've lost it. So it might come back to me. Yeah, Scott.
I've got a couple questions online that fit that last one.
Yes.
I'll just read them as they're chatted. By pro-religion, do you mean pro-Christian? How do you interpret the First Amendment, if not for government to keep hands off? And then another chat that said, again, doesn't side with religion really mean Christian? What if the football coach had been Muslim? So can you speak to the pro-religion versus pro-Christian distinction?
The $64,000 question. So that's a great point, and it's a great question, to which I'm going to duck a little bit because it remains to be seen. Okay, so one of the things that has happened with this court versus, say, right, the courts handling religion in the middle of the last century through the 50s, 60s, 70s, 80s is who are the claimants? Who are the ones bringing the lawsuits? And I described it, and there's been a real shift there from what I describe as claimants in the margins now to claimants in the mainstream. Okay, so you can go back, you can survey the religious liberty cases from the 50s, 60s, 70s. Who do they involve? Or sort of Christian, or sort of either non-Christians or marginal, right? Kind of Christian sects that are more on the margins, right? You had Native, right? In 1990, you had the Native American practice of ingesting peyote, right? The Jehovah's and their refusal to, right, to salute the flag, right? The Amish and whether the Amish and kind of their more peculiar practices and beliefs, right, could sort of prevail over the dominant laws that reflected mainstream Christianity, right? The Mormons, right? These are typically, right, these were claimants on the margins. And so so for much of the modern history of religion, it's been the court sort of mediating this tension between kind of religious groups on the margins who are butting up against conflicting with laws and policies that sort of invariably reflect, right, kind of the dominant Christian ethos that just sort of happened to reflect the kind of emerge, right, even not intentionally, in sort of the laws, right? So a Seventh-day Adventist in right, in the normal, right, back in the day, you all are wise and senior enough to remember the Sunday closing laws and that sort of thing, right? That has changed, right? So that has changed dramatically. And so you can, again, if you did a survey of religion cases in the last decade, who would you find? You would find primarily, mainly kind of mainstream Christian claimants. And so in Hobby Lobby, an evangelical family, the Green family who owns Hobby Lobby, right, conflicting with the contraceptive mandate in the Affordable Care Act. You have the traditional Christian baker, right, in Masterpiece Cake Shop, who's butting heads with the non-discrimination law. In Fulton versus Philadelphia, you have a Catholic family agency with placement practices that conflict with the city's non-discrimination requirements, right? Parochial schools that typically are Catholic or Baptist or Christian. So this has been a big change, okay? And so it's no longer that conflict between marginalized religions and mainstream culture, right? It's kind of mainstream. Proponents or adherents of kind of mainstream Christianity, but who are not necessarily in the dominant posture that Christianity was in the last century. Okay, so there is this change where they don't necessarily have the sort of the dominant cultural position. But in fact, now you have mainstream kind of Christian claimants who are sort of butting up against kind of secular cultural norms, and in particular, non-discrimination, right? A lot of times it's kind of, right, it has to do with sexuality and traditional views versus, right, versus growing norms around non-discrimination for LGBTQ. Okay, so those have tended to dominate, all right? Not exclusively. Not exclusively. So there's the cases that tend not to get the headlines. There are cases involving, right, strict Muslims, and can a woman wear a veil testifying in court, or right, a Jew with a head cover who's in prison. There are a whole variety of those kinds of claims. They're still out there. They tend not to be sort of headline grabbing. So it's hard, it is hard to speak too definitively in terms of the court. My hope certainly would be that the court is as vigilant in protecting those religious practices and exercises as it is for Christian claimants. That'll be the test. That'll be the test of the court's commitment to religious liberty. Yeah, that's a great question. Yeah, Scott.
I had one earlier question, slightly different. Could you compare the significance of Citizens United to the significance of Dobbs?
So people are familiar with Citizens United. How many are? How many aren't? You can, okay, if you see, but this is why I love HASP. I come here and, you know, here's a case that goes back to 2010, and more than half of you know what we're talking about. It's, you know, every time I meet with you, I go back to my students. I said, you know what these people are like? They're shaming you, folks. So Citizens United campaign finance case, right? 2010, a case in which the court said that corporations and unions fall within the definition of persons under free speech, under the Constitution. Okay, and as persons, they are entitled, right, that corporate entities and unions are entitled to the same speech rights as flesh and blood people. And so Citizens United really sort of eliminated campaign finance constraints on what corporations and other groups could contribute or spend on campaigns, and really kind of remove those constraints. How does that compare to, I have a very contrarian take on Citizens United. Not that I'm a big defender of it, but it was far less consequential than people think or thought. So it doesn't hold a candle to Dobbs, I don't think. I mean, Dobbs, we'll see what's going to happen with Dobbs. There's already been a lot of legislative activity around Dobbs. So that's it's just going to be really significant. Citizens United, I think the impact of it has probably been inflated. Okay, and in fact, my complaint was with Citizens. Did I say Dobbs? Citizens United, and an earlier case in the early 2000s, the McConnell case, and you put those two cases together, and they were a disaster. Okay, and the earlier case, so you have to know, I wrote a book on political parties. I used to be like a big proponent of the two-party system. I've now, in the last few years, I'm really reconsidering that. But parties really serve the purpose of channeling money in the system, controlling it, making sure you could make connections between money, contribution, spending, and the message, right? The message, who is doing it. And this earlier case, McConnell, did great damage to kind of political parties being able to be at the center of fundraising. Okay, so you put that together with Citizens United that allowed outside groups unfettered freedom to spend and to donate. You got a system that we have now, which is the money being channeled outside, right? Pushed to the margins, right? Dark money groups, because there are weak, right? There are weak reporting requirements and this, or you put them together and you have a system where parties have been subordinated to these outside groups. And everybody's cynical about parties, but guess what? Parties bring some intellectual coherence to campaigns and elections. And the least bad we can do is to try to funnel money as much as possible through the parties, because we know what the parties stand for. The parties are accountable. That cannot be said for dark money groups that are giving on the outside. The other reason I would say it's less significant than we might think is, like, empirical studies are showing money doesn't dictate. everything. People are now so cynical about money, about television ads, they tune them out. And so it's actually that, and now there's been this trend in small donors, Obama raised ungodly amounts of money through 10, 20, 30, $40 contributions. And there's been this trend of other ways of, raising money that have sort of balanced or worked against kind of the corporate money. That's not to say, I don't want to sugarcoat it and say it's not a problem. It still is a problem, right? Corporate influence is way too big, and you see it in both parties. But there you go. Yes, microphone.
I'd just like you to clarify something, and I think you just said it, David, that if I want to give to a candidate running for the state house in Michigan, I'm restricted to $1,050. But I think you're telling me the Michigan Railroads Association could give him $10,000. Is that what I heard you say? Because they're a PAC that is doing things. Am I thinking the right way or the wrong way?
No, that's essentially correct. Yep, that's essentially correct. But there's a lot more of us than there are a railroad PAC. There's probably one railroad PAC. There's millions of us in Michigan. So if you put all our $1,000 together, right? If you're a candidate or a party, right, who can animate the public, right, and right, gin up that kind of support, you put enough of them together, it's not necessarily inconsequential. Again, I don't want to just diminish the imbalance between corporate influence, but I don't think it is not the problem in our election system. It's a problem, I think. So, all right, let's see. 10:15. So I should probably move on from religion and leave some time at the end if we want to continue that. Point number 3, the court expects legislative institutions to actually legislate. Or you could say this court is pro-democracy, small d democracy. Looking to see if anyone's pulling rotten fruit out of their purse to throw in my direction. This is again, I'm looking for themes. I'm looking for some commonalities. This is something that is going on in the Dobbs case and in the West Virginia versus EPA case. And both of these can be explained, at least in part, by the court wanting lawmaking to be done by the lawmaking institutions, i.e. Congress and state legislatures. Okay, so that was Dobbs. Right. So Dobbs is the abortion case, right? If you don't know, just real quickly, right? Dobbs dealt with a Mississippi law, banned abortion after 15 weeks. So it was called kind of a gestational law is what, the gauge kind of the power of the state to ban abortion by just kind of the phase of gestation of the fetus rather than the question of viability, which has gone from 26 weeks down to 23 or something like that, but still a serious conflict, right, between a state law, a gestational law that allows the banning of abortion 15 weeks on versus Roe and Casey and viability allowing the banning of abortions from viability on, okay? And so that was the conflict that led to the Dobbs case. So the court sides with Mississippi, right? The court sides with the state. They uphold that gestational law by a 6-3 vote. Okay, 6-3, the 6 conservatives, but 5 of the 6 go further and overturn Roe and Casey as precedent. Okay, Chief Justice Roberts does not. Remember what I said about Roberts trying to sort of mediate the court, trying to sort of tamp down big, bold decisions that are going to make the court seem more political. All right. And so when the leaked opinion came out, right, it was leaked that Roberts was making a concerted effort to pull at least one of those 5 conservatives into his camp where they would vote to uphold the Mississippi law, but they would not go that further step and to overturn the precedents of Roe and Casey, which came a couple decades after Roe. His goal was to sort of take a more moderate, a more incremental approach and leave the question of Roe and Casey as precedent for another day. He did not get anyone else to do that, right? And so the five are successful in overturning Roe and the Casey decisions, right? We probably cannot rely on our friends in the media to do a very good job of helping us understand this case and right what it does and what it doesn't do. Okay. And so what it did do, right? It clearly overturned Roe and Casey. It did not outlaw abortion, right? What it did do was to say there's not a federal constitutional right under the 14th Amendment due process clause to abortion. Nor did it say the unborn are persons under the Constitution, under the 14th Amendment. So to their credit, the court, not our fight, not our battle. The Constitution, neither under the 14th Amendment liberty, right? The word liberty under the due process clause does not allow for a constitutional right to abortion, nor does that word person include the unborn. The court said, that's not our fight. That's not ours to say. So as you're reading about, each party now contemplating sort of federal legislation to weigh in on one side of the abortion issue or the other, be skeptical, right? Because the court would not be welcoming, I don't think, of a federal law on either side. And what the court did say is we are going to return this to a pre-Roe situation, i.e. states, this is your issue. Have at it. Okay, so the conservative or the small d Democratic objection to Roe all along was that Roe preempted what was really sort of a fertile time of activity and politics and legislating at the state level in the late 60s and the early 70s. Okay, and there was, I don't want to oversell the the liberalizing of abortion law, but there was some liberalizing. There was in some places, right, it was pretty restrictive, but some states were starting to grant abortion rights under state law, right? Roe came in 1973 and preempted 50 states' individual laws on abortion. Okay, so this court is saying, yep, we are returning this to the proper venue, right? If there's not a federal right to an abortion, if there's not a constitutional interpretation that says the unborn are included in that word person, this is a political issue and a moral issue, but it's not a federal constitutional issue, right? So, and guess what? What has happened since Dobbs came out? Like we're seeing a lot, right? We're seeing a lot at the state level. Some states had trigger laws that sort of triggered their state abortion law immediately. Those are finding their way into state courts. We had if you're following the news, right, Kansas had a ballot initiative here a couple of weeks ago that sought to take the right to an abortion out of the Kansas state constitution, and it failed. And so there's sort of this flurry of activity, and it's going to be with us for some time. It's not like this is going to magically de-escalate abortion as an issue, but it is moving it in a decentralized direction. So that's the Dobbs case, all right? And then we have the West Virginia versus EPA case. This one's a little more technical for most folks. I would say it's arguably no less important for the long term. This one is less about rights. This is more about sort of how government works. Okay, and it's very much a sort of a separation of powers question. And in this case, so it involved the EPA enacting rules that capped power plant emissions. And the goal of that was to shift American reliance on energy from fossil fuel to alternatives and to sustainables. And the court struck down the EPA's authority to enact that law. Okay. And the court said administrative agencies may not promulgate or enact rules that have, quote, major economic and political significance, unquote, without clear congressional authorization. Got that? That's really important. And so it's called the Major Questions Doctrine. Okay. And it basically says an agency cannot enact what is a major economic or political rule without there being explicit, clear directions, instructions, authorization from Congress. And that was not the case here. Okay. If you know anything about administrative law, that could be potentially earth-shaking in terms of what it might suggest for the future. So, right, we have a system, and basically what the court is saying, so I'm gonna curse here, okay, so apologize. Congress, do your damn job, is basically what they're saying. Congress, do your job, okay? Because Congress has not been doing its job. And so 40 years plus, this goes back to the 70s and even before, right? How do agencies come into being? How do agencies have the authority to do what they do? Theoretically, they get it from Congress. Congress passes a law. And then, right, and that law tries to accomplish something. And then Congress delegates to the appropriate agency the particulars, the details, the minutia, right? Congress passes a law that is supposed to say, we're doing this, we're accomplishing this, okay? And then you, EPA or whatever the agency is, you are going to do the minutia in carrying it out. Okay, and what has happened and so that's what has given us this fourth branch, what's called the fourth branch of the administrative state, the federal bureaucracy. Okay, and basically Congress has gotten really lazy, and the more that bureaucracy has grown, the less equipped 535 federal lawmakers are to ride herd over it, to supervise, right, to keep an eye on what it's doing. So Congress has become really good at passing laws, claiming credit for passing laws, and then just giving the appropriate agency a completely free hand. Go do what you want to do. Okay, and they know, right, and this has just become standard practice, and it doesn't matter whether it's a Republican majority in Congress or a Democratic majority, everybody does it. But it means Congress has quit doing its job. And the court is saying, Congress, you need to do your job. Why? Why? Because, because Congress represents us, right? And if we don't like Congress, we can do something about it, right? They are answerable to us. They are accountable to us. The federal bureaucracy is not answerable to us. They're not accountable, right? That is the nature of the bureaucratic state. Now, what happens here, I don't know. This is going to be interesting to watch. Again, in theory, I'm all for this, right? If any of you have been maybe involved in the rulemaking process for a federal agency trying to pass a rule, there is a phase called the public comment section. But unless you have one of those wealthy lobbyists working in your corner, guess what, average American? You are not going to have input into that public comment process. It is a process that it's closed, it's held hostage by special interests, right? It is not sort of democratically grounded. And so, right, when liberals look at this, who are more kind of comfortable with the administrative state, and they are gnashing their teeth, they have a reason to. Right? This could be really consequential. conservatives who don't like the federal bureaucracy, we'll see if they put their money where their mouth is. And when they have control over Congress, are they going to do the hard, sort of dirty work of providing explicit instructions, authorization for agencies to do what they're telling them to do? And then are they going to engage in oversight of that agency? So that's what's at stake here. And again, it's saying, Congress, you're the lawmaking body, you're the legislative body, do your job. Okay, yes.
This is a question, I think it's, oh, sorry. Let me get the mic here. This is a question. A Michigan state representative told me that she was sitting down with a 40-year-old state of Michigan bureaucrat and had some proposal, whatever it was. And his comment was, look, you're term limited in 6 years and I'm not retiring till 65. So I'm around a lot longer than you are. Is that a problem too at the state level where, and if I'm getting out of your talk, just tell me, hey, you're asking the wrong question, but
that's the nature of the bureaucracy, right? So, the nature of the bureaucracy is it's governance by expert, right? And sort of the nature of administrative law and practice, it flows out of the progressive era of 100 years ago, right? And we were of a mindset that, right, well, state legislatures, they're a bunch of amateurish hacks, right? Same with Congress people, right? We populate these federal and state agencies with the experts and we let them do their jobs. Guess what? That idea is not so popular right now, right? There's lots of questioning going on of experts. It's a matter of scale, right? So it is I would say what you described, yeah, it's not, at the federal level, just to let you know, we still have federal bureaucrats who were in their office during the Reagan presidency. Reagan, remember him? I was in law school when Reagan was president, right? They are settled, they have their turf, they have their administrative sort of view, and guess what? They will not be shaken. And out of a federal bureaucracy of a couple million, we have this little sliver of, I think, 4,000 political appointees who an incoming administration can fill. And those 4,000 are supposed to kind of move and direct that 2 million plus federal bureaucrats who have their turf and their issues, their bureaucratic mindset. It exists at the state level. It's a matter of scale, right? It's not as kind of huge, and the dysfunction is probably not as acute as it is at the federal level, but it's still there. Yeah. Yeah, Scott.
We have a question from online on that topic. Are you advocating that Congress should oversee the public comment section of law rules and regulations to implement a new law? Let's say, for example, implementing clean water for Flint. How should Congress handle getting down in the weeds without any bureaucracy?
I don't think we would say do away with the bureaucracy, right? No, so yeah, because yes, if you hear conservatives talk about those bloody bureaucrats, right, and they spit it out, it's a dirty word. It's it's an epitaph to be called a bureaucrat. But no, I mean, the bureaucracy does an incredible amount of good, right? Whether it's at the federal level or at the state level, right? It is agencies that are doing the bulk of the distribution of goods and benefits and programs from which we all benefit. Okay, so I'm saying you have to hold that in balance with sort of the administrative processes that really work against them sort of having some kind of democratic grounding. And so I would not, it's not Congress's job to go to the public comments section. I think bureaucrats read those public comments, they pay attention. I mean, the system requires that they take them into account and respond, and they'll come up with an amended rule. So it's not like they ignore that, but the public comment section is not going to have a lot of input from Joe and Jane six-pack walking down the street, right? Normal, everyday people. But I don't want to suggest this is easy. I mean, I think this is a real challenge, is how do we allow the bureaucracy to do what they do in a system where we've become so dependent on them, and where the office holders, the lawmakers, have become so dependent on them. Right? That they're going to continue to be there, but how do we animate federal Congress and state legislatures to do their jobs? I mean, they have capitulated. They've capitulated the role of lawmaker in so many ways. So I don't know. I can't predict what sort of the proper balance is, but I do think this case, take it out of the specific issue of climate change and put it more generally in the context of sort of bureaucratic and administrative law in the administrative state, and how they get plugged into a democratic system of governance. And it's a problem. It's a theoretical and a practical problem. And so in that way, this could be a very important kind of start to require Congress to start doing their jobs again. Now, the problem with that is we also have a Congress that is so darn partisan, so binary, right? Is Congress going to be able to get back to the point where they can actually legislate from the center and get some things done? And that's another conversation for another session. Yeah.
David, I would like to hear you allay my suspicion that we are not getting much of a public education. We're getting education by media, and I think people who vote these congressmen into office and women are often very ignorant of the process of government. They listen to the fast and glamorous and expensive message and don't know what they're talking about.
Yeah, you're speaking to the choir, Peg, at least a one-man choir. Yeah, especially as I think about the court and in judicial decisions, they're a little more dense. There can be a little more esoteric, a little tougher to dive into and understand. That we tend to be really reliant. Not too many of you are gonna. As a teacher, and I teach law courses, and I have to get my hands on edited opinions if I'm going to use them because I'm too lazy to edit them myself. That's not true. I've just got other things to do, but it's hard to find them. And if you all probably can't find those edited opinions, are you going to go and read the 119-page opinion on Dobbs? And was that just the majority opinion, or was that all? It was probably just the majority opinion, right? These opinions are 60, 70, 80, 90, 100 pages. The court is supposed to justify and rationalize what it does through an opinion that convinces us, right? It has a sound basis for doing what it's doing. Most of us are not going to go to SCOTUS blog or Supreme Court law and read these cases. We're reliant, right? We're reliant on the media. There is a dearth of good kind of Supreme Court reportage out there. Charles Lane, he doesn't do it anymore, unfortunately, for the Washington Post, was really good. He's given away to someone else. But here again, what we get from the media is sort of these competing narratives. And so, reading the coverage on Dobbs has been stunning to me. And the amount of, I'm going to attribute it to ignorance I won't say it's disingenuous or disinformation. I'll give them credit for at least just being ignorant and not intentionally trying to lead us astray. So one of the things I do want to talk about is sort of the legitimacy crisis that the court now finds itself in. And how much of that is attributable to narratives from the media, because they are not really helping us understand what was at the heart of it and what's going on. So I think it's a problem. I don't know where we start what we start to do about it, but yeah.
Like on the administrative law case, if the Congress' clear intent is to delegate authority to an administrative agency, wouldn't that cut against the Supreme Court saying, do your job? If they say we did our job by saying we want somebody else to do our job.
Right, that's the argument on the other side. That's it exactly. That's what
Okay.
they say.
And then,
Yeah.
and then
So,
this-
but just to clarify, so what is happening, how this plays out, then you get an agency rule where there's not clear directive from Congress. That's what Congress says. Well, this is about clean air. Okay, EPA, do whatever you want, right? And then what the court has said, and then somebody will invariably challenge that, right? And saying, well, you don't have the authority to do that. Works its way up to the court. The rule has been, so here's how the change plays out in the West Virginia case. The court will say, we are simply going to defer to the agency. And that has been going back to Chevron in the famous Chevron case, 1974. The court simply says, we're going to defer to the agency interpretation. Okay, this court is saying, no, you can't. They do not have the democratic sort of founding under a system of separated powers. So Congress is essentially saying, well, we give this over to you and you make the law. That's not the executive branch. The administrative branch is not about making the law. They're about carrying out, that's why they are in the executive branch, right? They're about executing, carrying out what Congress has directed them to do. If Congress does what you're saying, then I'm saying, no, Congress is simply delegating the lawmaking function, and you can't do that under a system of separate
Yeah, so
powers.
the argument is whether it's a law or it's a regulation. So they're saying like if.
Sure, they need to look beyond how it's characterized and saying, what is this? Is this a kind of executing of what Congress has passed? Is it putting the details, the flesh on the well-defined skeleton that Congress has given us? Or is it more in its nature? Is it lawmaking? And that's a blurry line, right? But that was an issue that came up in the context of immigration. Under both the Obama administration and then subsequently under the Trump administration. And right, the court said, right, Obama by executive order and then giving over to the agencies was not tweaking, executing, carrying out existing immigration law. The changes were so profound that it essentially amounted to lawmaking, and hence violated separation of powers.
Okay. And
Yeah.
if I could just on
Sure.
the Dobbs case, do you think there's a threat there to unenumerated rights and that would carry over to other cases? And the due process,
Good,
rights
yeah.
found in the.
Yeah, because that's an important question, right? And so the argument for abortion rights. So one of the problems was that back in 1973, Harry Blackmun, if you haven't read the opinion, you should read it. Harry Blackmun sought to ground abortion rights in the 14th Amendment due process clause, which had a very checkered and really stigmatized reputation going back to the early 1900s. And I would say rightfully so, because it was substantive due process. It was taking a procedural clause in the Constitution and trying to make it a source of substantive rights. Didn't make sense in the early 1900s, didn't make sense in 1973. There could have been a better argument under the 9th Amendment, which talks about other unenumerated rights, right? That the rights listed in the first 8 amendments, the first 8 amendments in the Bill of Rights, just because those are listed does not mean those are the sum and substance of our rights. The 9th Amendment allows for other unenumerated rights. It still would have been a tough road, I think, for abortion rights advocates, but it would have made more sense. But in any event, yes, the opinion by Sam Alito and the general standard for unenumerated rights has been what is the kind of the history and the traditions of the American people. And if there's a long history and it is sort of grows out of the traditions of the American people, that might be identified as an unenumerated right that would have protection under the Constitution. What has happened, and we can kind of thank Clarence Thomas for this, who wrote his concurring opinion. He was the only one that said, as is so often the case with Thomas, he is so principled in his adherence to his way of viewing things, it takes him to some scary places. Okay, so he said we really should consider substantive due process in the 14th Amendment and all granting of rights that have been given under the 14th Amendment, including same-sex marriage, the right to contraception. Yeah, it's like, so if. But not interracial marriage. Yeah, well, but that was an equal protection. That was more of an equal protection. Here we're talking due process, right? But the point being, yeah, I mean, if you wanted to make hay with this argument, you glom on to Thomas's concurrence. Everybody else was very careful to say, no, this is unique because there are these two interests involved, right? There's the interest of the unborn as well. And I don't know how many times the majority opinion said, no, we're not going there. We're not doing that. Ultimately, it's important to remember that right, the court is insulated from public opinion. That does not mean the court is oblivious to public opinion, right? They do pay attention. Okay, the opinion surveys on abortion are so complicated and nuanced. And they've been completely misrepresented by the media. That's not the case on same-sex marriage, right? Public acceptance of same-sex marriage just continues to gain steam. It's large majorities of the country, okay? Unless a conservative majority really wants to completely undermine their public standing, they're not gonna go there, right? A colleague of mine after Dobbs came down, who's not very well read on constitutional matters, right, texted me and was beside herself, worried about access to contraception. And I had to tell her, I don't think you need to be worried. I don't think that's an issue. So, all right, can I move on? So we're down to about 15 minutes. So takeaway number 4 is originalism as kind of the majority's settled mode of constitutional analysis and interpretation. And increasingly, that is bringing the liberal members of the court in as well. Okay, and this was the New York Rifle and Pistol Association versus Brune case. This is the gun case. Okay, and it's a case that is significant for the mode by which the case was decided. That's where the significance lies, much more than kind of the particular policy that was at issue. I don't think many people honestly thought the New York gun law was going to survive. Okay, it required, so someone, if they wanted to carry a gun in public, they had to get a permit. And to get a permit, they had to make a showing of a special peril, a special danger. Besides kind of the just everyday sort of danger, let's say being in a unsafe neighborhood, a crime-riddled neighborhood, that would not be enough. It had to be some special showing of some special peril or risk for which one needed a gun for their self-defense. Number one. And number two, they had to convince a licensing agent of that special peril. So the discretion to grant the permit was in the hands of this licensing agent. That's a quirky law. And I think it was pretty clear that was not going to pass muster on what the court found to be, right, a constitutional right to keep and bear arms for self-defense for safety purposes under the Heller case back in 2010. Okay, so that's the particulars of it. The way in which the court decided it is a big deal. And this is probably the most originalist opinion coming from the most originalist of the justices, i.e. Justice Thomas. And it's really interesting to read. There's much of it that I find head scratching. I still can't quite sort of understand some of what he is doing. But the gist of it was not only, so 2010, the late Justice Scalia wrote the majority opinion, and it was an originalist opinion, finding an individual right to keep and bear arms under the Second Amendment. Okay. Scalia, in that opinion, said this does not prevent state and federal governments from enacting reasonable regulation on the usage of guns. And so since then, lower courts have essentially been kind of engaged in like a balancing test, right? The right of the individual for self-defense kind of balanced against the interests of the state and the public. In this case, in Bruin, Thomas said, not only does the original history support an individual right to keep and bear arms, but any regulations by the state or by the city have to also match originalist history. Okay. Well, I haven't quite figured out how are you going to do that? How are you going to judge, right, the appropriateness of a regulation on gun usage by looking at what was going on in 1791 or 1792? Thomas talked about, well, it doesn't need to be exact. It's by analogy. Were there regulations then that are analogous to regulations now? I don't know what to make of this other than originalism is going to be a high hurdle, and it's going to make it harder for governmental entities to come up with regulations to pass muster. So that case is going on, right? Dobbs had an originalist slant to it. The religion cases have really kind of gone about trying to arrive at an understanding of the religion clauses that is more aligned with history. And so originalism has cachet with the court. And we'll see. If you want, here again, I think you should go spend your time reading Supreme Court opinions. But you can go back to 2010 and you can read the Heller case that Scalia wrote, and you can read the dissent by John Paul Stevens, who made the argument against the individual right to keep and bear arms from an originalist historical point of view. It was really interesting. It was these clashing exercises in history and originalism. So this is going to be, here we go again. This is going to be interesting to watch. And it remains to be seen whether the liberal justices are willing to take that on and start making arguments out of the history and out of the text. Right? It's easy. And my students always find this, well, Dr. Ryden, originalism, how the heck can you go back to sort of something in 1791 or 1868? How do you do that? I have my own answer to that, but it's an obstacle, right? That's a hard thing to do. Remember, the argument from the conservative standpoint is, and this was in Thomas's opinion, and it's been characterized as text plus history. Text plus history. And this is an approach that is, at least in theory, aiming for a more objective mode of judicial decision making, right? The goal, at least in theory, right, is to take the court's personal predilections, policy preferences, individual kind of values, to take those out of the equation, because why should they be able to do it? Right? So text and history are meant to be ways of constraining a judiciary that enjoys life tenure, that is not elected, that is not answerable to the public. Okay. All right. We have about 8 minutes left. And I have my 4 questions regarding the court's future. Let me just touch on these and then I'll shut up and we'll have a few minutes, right? I mean, the court is in a legitimacy crisis. The question is whether it is permanent or whether it's transitory. The court has, the Supreme Court has traditionally been immune to a lot of the disapproval and cynicism that the public has had towards other institutions. Okay, that's kind of changed. And there have been, like recently, there was a poll over the summer that put the approval rating of the court at 40%, historically low. Okay, so what's going on there? Is that Dobbs? Is that cases that just seem more political? Stay tuned. Is it something that is short term and the court will gradually kind of reestablish its standing in the public's eyes? And will that shape what the court does in the future, right? So the court has another religious liberty case in the fall. It's got affirmative action on the docket in the fall. It's got some other big cases, right? These cases that are politically laden, especially when we have a media that may not be an honest broker in helping us understand them. Will those continue to chip away at the court's standing? Number one. Number two, did I get this right? Precedent. Yeah. So the court has been attacked from many sides for overturning Roe and Casey. And so there's been a criticism from some corners that this court doesn't care about precedent. And that this court is going to be extreme, it's going to be reactionary, it's going to be tossing aside existing precedents right and left. I am skeptical of that argument. If you go back and you can count up, and again, there are lots of different ways to figure out what counts as an overturned precedent. The Warren Court from 53 to 69, something like 32 by one count. The Berger Court from 69 to 80, whatever it was, 85, 86, 32 overturned precedents. The Rehnquist Court from 86 to 2005, 30. The Roberts Court from 2005 to 2022, 15 or 16. Okay, so they're within boundaries. Okay, number one. Number two, Roe is simply a bad case to make judgments about the standing of precedent. So precedent matters. So first of all, precedent is not a hard and fast rule. It's not a straitjacket. It's a guide that courts use to make their jobs easier, to help them to be more efficient, to help them not have to remake the wheel every time a new case comes down the pike. Okay, and it is also meant to kind of give us law that has some stability to it, to ensure that every time we get a change in that balance, that the law is not zigzagging back and forth, that we have continuity, predictability, so that people can gauge their behavior accordingly, these sorts of things, right? So typically the court, in deciding whether to overturn a precedent, is going to look at, right, was the case wrongly decided? Has there been reliance on it? Some other kind of technical factors. The thing about Roe is it is, right, by a sizable minority, it's never been accepted, right? That you, and in that case, in that sense, it's really sort of unique. And so I wouldn't make too broad of sort of extrapolating from Roe what the court is going to do on other precedents. Having said that, remember, this is the most conservative court in 90 years. They're going to meet some precedent that they don't like. And so the affirmative action case, I'm a betting man. It's like there's some precedent that will be set aside come fall. I would bet. All right. Whose court is it anyway? The likelihood of reform in the future, I don't know. You know, there's so much, yes, and right, we now have this binary political system, and so in the wake of a conservative term, everyone on the left, of course, wants to pack the court. That would work well, I'm sure. I've argued for 18-year terms. Other reforms would be to pare back the court's jurisdiction over certain matters. I would question the idea that we have a serious problem with the court. I think that's a narrative that has taken root. And I wouldn't mind if justices were not on the court for 35 years, 34, 35, 36 years. That's one thing. I would go for the 18-year term limits. Otherwise, I don't think the court is a deeply dysfunctional institution. All right, I'll be quiet. We got a few minutes for questions. Yeah.
Similar to the last topic you were on, I had a question in the chat earlier about the size of the court, who sets it, and any discussion on current efforts to increase the size of the Supreme Court.
Yes. So the size of the court is set by Congress. So one, in terms of checks and balances, one of the checks that Congress has is it gets to regulate the court. So packing the court, Congress has every prerogative, right? So we have instances from the court being at 6, and then went up to 7, right? And then went down to 5, and then went up to 9, right? And it's always for political reasons. It's always politics. But the thing is, it hasn't happened since 1868 or 1869, right? So yes, Congress has the authority and the freedom to do it, but now we kind of have this norm that has taken root, right? And so it's been 150 years where it hasn't changed. So people are going to look askance at that. And the other thing is because of this binary system. So help me, if Democrats do it now, right? Well, guess what? The Republicans will probably resume majority status at some point, and it'll be this escalating, or rather this descending down a drain kind of tit for tat. So yeah. Other question over here.
With the decisions made by what I call the McConnell Court, have we just opened the door to total chaos? That any regulation made by a bureaucrat or by a branch can be challenged because Congress didn't specifically demand that act?
I don't know if that's total chaos, but if this suggests this major question doctrine now has some backbone, right? That there's something to it. So we'll see. It could be chaos. I don't think so. But it might mean that Congress has to be more explicit. They're going to have to read the bills before they pass them. And they're going to have some kind of more clear authorization. And that's what I like, that label, kind of clear authorization, sort of a term of art. And yeah, to me, that would not be a bad thing. Again, how much further back we swing in the direction of Congress needing to do a better job, I'm not sure. The sort of the bureaucratic administrative agencies are always just the reality of the modern state and complex society. They're always going to have a good deal of discretion. But, I think there could be some bounds that are workable, but we'll see what happens. Yeah, we'll see. Yes.
I just wondering, just from an academic standpoint, when you read cases, is there a difference between the way you look at them as a law student, a lawyer, versus as a political scientist? Or is it just that political science covers different areas, and when you read the cases, you read them as you would as a lawyer?
Yeah, that's a good question. How do you read it differently through a legal lens versus a political lens? I took constitutional law in law school. I never sensed that I had a picture of the forest for the trees. And so there was a tendency to view and to study constitutional questions in an isolated kind of way, right? To look at a discrete question coming from a discrete provision, right? Political science has helped immensely in giving me the backdrop, giving me the theoretical, giving me the sense of the whole, and yeah, sort of doing all of that. My dissertation, which I then turned into a book, was a critique of the court, the Supreme, oh goodness sakes. Professional, really professional. My family, so we were just on vacation, and I still have this jazz riff on the piano on my ringtone. Do you know which one that is? Yeah, and they said, Dad, well, like, what are you doing? Get rid of that ringtone. So we started looking through the ringtone, and there's one barking dogs. So I love dogs. I have a dog at home. And so I changed it to a barking dog. And now I'll be like walking around, and I'll hear this dog barking. Yeah. And I am not tuned into my phone. So, but that was bad. That was bad. So, what was I saying? Forest for the trees. My dissertation and then this book was looking at the court and its jurisprudence dealing with group politics, with political parties and interest groups. Okay. And it was a great exercise because the first thing I did was do this very thorough, and I built this theoretical case for how a court that was well grounded in politics, political theory, political science would have a well-formed approach to dealing with the rights of political parties and interest groups and the like. And it was critiquing the court in every one of these different areas: campaign finance, redistricting, ballot access, all these sorts of ways. And they completely failed to do that. That is, and I think that is a reflection of the legal academy as well. And it's a problem, right? So one of the problems with originalism is like justices and law clerks may not be very good at doing history, right? I also don't think they're very good at doing political theory, right? They're not good at doing a lot of other things too. So yes, as a political scientist with the background in law, I've been able to read cases with kind of, having that legal training, but sort of the political science has really been very helpful. Yeah. So, right, when we do constitutional law, that is a political science course over at Hope College because we're putting it in a political context. Okay. I've gone too long. Are we good? All right.